Good afternoon. This is Sean Golden with Golding & Golding, here to discuss a little bit about the closer connection exception to the substantial presence test, how it works, who qualifies, and what you may be able to do if you don't qualify. So, substantial presence, let's start there. Typically, for a U.S. citizen or a lawful permanent resident, assuming no treaty election is made or anything like that, they are taxed on their worldwide income. So you're a U.S. citizen, you live in a foreign country, you're earning income from a foreign country. You may even pay tax in that foreign country, but from a U.S. tax perspective, you're taxed on that worldwide income. And you may have foreign tax credits to offset it, but the baseline is that the U.S. taxes you based on your U.S. person status. Most countries tax you on your worldwide income based on how long you've been living in the country. So you've got U.S. citizens and you have lawful permanent residents, but there's a third catch-all category, and that's referred to as taxpayers who meet the substantial presence test. It's for people who are non-U.S. citizens and non-lawful permanent residents. Generally, it's going to be visa holders, right? It doesn't have to be, but you're here on a work transfer L1 or just an H-1B work visa, an E2, kind of like a treaty investor visa, EB-5 investment visa, B1, B2 tourist visa. Conceptually, any type of visa, right? Some people think it's only employment, but it's not. It's any type of visa. And what you have to do is count the number of days. If you were in the United States for 100, let's say 90 days 2 years ago, then you divide that by 6. And if the prior year, you divide by 3. And the current year, you divide by 1, just 1 to 1. So 1-to-1 ratio in the current year, 3-to-1 ratio in the preceding year, 6-to-1 ratio 2 years back. You mix it all in a pot, you add that up, and if you exceed the number of days, then you're subject to the substantial presence test, worldwide income. So for taxpayers who are like, well, I'm not a U.S. citizen or lawful permanent resident. Yeah, I stayed in the country for a significant amount of time in these last few years, but I'm still a citizen of country X, and I still have, closer connection or significant contacts in that country, then you may be able to qualify for the closer connection exception. So the way it works technically is that let's say you're here on a visa. Based on the number of days you were here in the current year and the 2 preceding years, you exceed the number of days, so you qualify under the substantial presence test, or you meet the substantial presence test, which now means you're taxed on your worldwide income, just as if you were a citizen or a lawful permanent resident. However, if you can show that you meet the closer connection exception, then you won't be taxed on your worldwide income. You'll only be taxed on your U.S. sourced income. And there are some few requirements. The 2 main requirements is that you're in the United States for less than 183 days in the current year, right? Less than half the year, essentially. And you have a closer connection to a foreign country or foreign countries. And basically what you have to show is you have significant contacts with that country. You have a tax home in that country. Let's say maybe you have a home in that country. None of these are particular specific requirements, but you have a home, voter registration, you have a car, you have utilities set up, maybe your children go to school there, or you have family members there, you vote there, all that kind of stuff. You mix it in a pot, and if you can show you have significant contacts in one country or multiple countries, the tests are a little different depending if it's one country or multiple countries, then you could say, hey, IRS, yes, I did meet the substantial presence test, but no, I'm not going to be taxed on my worldwide income because I qualify for the closer connection exception. One of the most important components of trying to use the closer connection exception is that you can't have started like the lawful permanent resident green card process yet. Why? Because if you started that process, then essentially what you're saying is your goal, your intent is to be in the United States and to make that your home as a lawful permanent resident. So it would not work in the sense that if you were trying to show you have significant contacts in a tax home overseas, it would impact your green card application. So write directly in the 8840 in the instructions. The Form 8840 is what you use to file a closer connection exception. You file that with your 1040 NR. But if you already started the process, then it doesn't qualify. And they list out the different forms. You can normally find it in the instructions. If not, there's various publications that explain what forms, if you start submitting those forms to USCIS immigration, then you no longer qualify for the closer connection exception. Excuse me. Even if you don't qualify for the closer connection exception, there's other things you may be able to do. You may be able to make a treaty election. You may qualify for an 8843 exception, certain researchers, teachers, things like that. So you're not automatically stuck, but closer connection exception tends to be one of the easier ones if you qualify and can show significant context. If you're only learning that that you are a U.S. person for tax purposes and thus you should have been filing various international information reporting forms, FBAR, FATCA, Form 8938, etc., then you're out of compliance and you could be subject to fines and penalties. But the IRS has developed various offshore amnesty programs to assist taxpayers who are out of compliance. If you're willful, you do the VDP program, voluntary disclosure program. But if you didn't know, typically you're going to be non-willful. And if you're non-willful, there's various other options available: streamlined procedures, delinquency procedures, and reasonable cause, where the penalty is minimized or even waived. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.